Okay, let's start with something pretty tough to imagine for some, but very real for others. Picture this. You lose your driver's license.
Yeah, and not for, like, bad driving or anything reckless.
Exactly. Just because you couldn't manage to pay court fees, maybe a fine you couldn't afford, suddenly your way to work, to get kids to school, your basic mobility, it's just gone.
It's a huge civil rights issue, really. And a group of Virginia drivers, they decided they had to fight this in court.
Right, and they actually won a pretty big victory, at least for a while. They got the state to stop taking licenses under that rule.
But then things got complicated. The state legislature just went ahead and repealed the law they were fighting against. Poof, the legal problem vanished.
So the law they hated, gone. The drivers, safe from that specific threat. Sounds like a win, doesn't it?
Well, not quite so simple when it comes to the lawyers' bills.
Okay. And that's what we're diving into today. This recent Supreme Court case, Lackey v. Stinney, decided just February 25th, 2025.
Yeah, this deep dive is all about that tricky situation. What happens when you win a major battle in court? The government basically throws in the towel early, but maybe before the final legal bell rings.
And the big question, does the lawyer who forced that change still get paid?
Exactly. Our mission today is to unpack this specific legal puzzle. Were these drivers technically prevailing parties under federal law? That's Section 1988, the Civil Rights Fee Law.
Even though their only court win was temporary, a preliminary injunction, before the whole case became, what's the term?
Moot.
Moot, yeah. Meaning the underlying issue resolved itself outside the courtroom.
Okay, so let's set the scene a bit more. The original fight was about a Virginia law, right? Section 46.2395B.
That's the one. It let the state suspend licenses purely for unpaid court fines or costs.
And the drivers argued this was just fundamentally unfair, especially for people who literally couldn't afford to pay. They said it violated their constitutional rights, right? Due process, equal protection. They brought the case under Section 1983, that's the main tool citizens have to sue state or local governments over constitutional violations.
Okay, let's walk through how this actually unfolded. The drivers filed the lawsuit. What were they hoping for immediately?
Well, they needed immediate help. You can't wait years for a final court decision if you can't drive now. So their first goal was to stop the state from enforcing that law against them right away.
And did the first court, the district court, agree?
It did. In December 2018, the court looked at their arguments and said, yeah, it looks like you're likely to succeed on the merits here. Based on that likelihood, it granted a preliminary injunction.
A preliminary injunction. That sounds significant, even if it's labeled preliminary. What did it actually do for these people?
Oh, it was huge for them personally. It meant they could get back behind the wheel while the case continued. It literally stopped the state commissioner from suspending licenses under that specific statute, at least for the people involved in the suit.
So, real-world impact, they could drive again.
Absolutely. For 16 months, actually. That piece of paper from the judge made a massive difference in their daily lives. Keeping jobs, getting groceries, all of it.
But then came the twist you mentioned.
Right, the twist. While the lawsuit is still working its way through the system, about 16 months after that injunction, in April 2020,
What happens?
the Virginia General Assembly steps in. They completely repeal the law being challenged. Section 46.2395. Gone. And they even required the state to reinstate licenses that had been suspended under it.
Wow. So the entire reason for the lawsuit just evaporated.
Exactly. The law was off the books. Legally speaking, the case became moot. There was no longer an active controversy for the court to resolve.
Okay, so the drivers got what they ultimately wanted. The bad law is gone. But they never got that final court ruling saying, yes, you were right, this law was unconstitutional.
Precisely. They only had that preliminary finding that they were likely to win.
And this is where the money question comes in. Paying the lawyers who did all that work.
Correct. Enter Section 1988B. Most people know the usual American rule in lawsuits. Everybody pays their own lawyer, win or lose.
Right.
But Congress made a big exception for civil rights cases like this one. Section 1988B allows courts to make the losing side, usually the government defendant, pay the winning side's attorney's fees.
Why did Congress do that?
To encourage lawyers to take these kinds of cases. Fighting the government is expensive, and people whose rights are violated often don't have deep pockets. This law helps ensure they can actually find representation.
But there's a catch, right? You have to be a
prevailing party.
Yeah.
That's the magic phrase.
Yeah.
And that became the whole fight here.
And the lower courts couldn't agree on whether these drivers, with their temporary win followed by the law's repeal, actually prevailed.
Complete disagreement. The first court, the district court, said no. preliminary relief isn't enough. You didn't get a final judgment. So, no fees.
But the appeals court saw it differently.
The Fourth Circuit Court of Appeals did. They heard the case en banc. That means a larger panel of judges reviewed it, and they reversed the district court.
What was their reasoning?
They said, look, this preliminary injunction, combined with the fact that the state then repealed the law, did give the plaintiffs enduring relief that was based on the merits. They argued it should count. They essentially achieved their goal because of the lawsuit, even without a final order.
That makes a lot of practical sense, doesn't it? I mean, the lawsuit clearly led to the change. Why shouldn't that count?
You'd think so. But the Supreme Court took a much more, let's say, formalistic view.
Okay, so bring us to the Supreme Court's ruling in Lackey. What was the bottom line?
The bottom line, delivered in an opinion by Chief Justice Roberts, was definitive. No, these drivers are not prevailing parties under Section 1988B.
Wow. So they sided with the district court's initial view. Why? What was the legal standard they set?
They laid out a very clear, what they call the bright line rule. To be a prevailing party, you need two things. First, you need enduring judicial relief on the merits that materially altered the legal relationship between you and the defendant.
Okay. Enduring relief changes the relationship based on the merits. Sounds like a high bar. What's the second part?
The second part is critical. The enduring nature of that relief must itself be judicially sanctioned. It has to come from the court's power, not from something else, like the legislature acting.
Let's break that down. Judicially sanctioned. That means the judge has to order the permanent fix, right? Not just the temporary one.
Exactly. Think of it like needing the court's official final stamp of approval on the permanence of the win.
So why doesn't a preliminary injunction meet that standard? It comes from a judge.
Because it's inherently temporary and tentative. The judge isn't making a final decision on the merits. They're just saying, it looks like you'll probably win, and the situation is urgent, so let's freeze things for now.
It's about preserving the status quo, not making a final call.
Right. The court cited an earlier case, University of Texas v. Kamenish, for that point. A preliminary injunction's purpose is just to keep things stable until a full trial can happen.
So it's like a legal pause button, not the final chapter.
Yeah.
Did the court use other past cases to back this up?
Oh, yes. They leaned heavily on precedent. Two cases were really key. First, Buchanan.
What did Buchanan establish?
Buchanan rejected what was called the catalyst theory. That was the idea that you should get fees if your lawsuit was simply the catalyst that caused the defendant, the government, maybe to voluntarily change its ways.
Like the legislature repealing the law here.
Exactly like that. The Buchanan court said, no, that's not enough. The change has to have a judicial imprimatur, that official court stamp. It can't just be the defendant deciding to back down on their own.
Okay, so Buchanan says the judge has to order the change. What about the enduring part? How long does that order need to last?
That brings us to the second key case, Soule v. Weiner.
Soule. What's the rule from that one?
Soule dealt with a plaintiff who won a preliminary injunction, got that temporary relief, but then later lost the case when it came to the final decision on a permanent injunction.
Ah, so they won the battle but lost the war, legally speaking.
Right. And the court in Soule said, well, you didn't prevail overall because that initial victory was ultimately transient. It didn't last.
So how did the court apply Buchanan and Soule here in Lackey?
They put them together. They said, look, the only court order here was the preliminary injunction, which Soule tells us is transient, not enduring. The actual enduring change, the law being repealed, came from the legislature, which Buchanan tells us lacks that necessary judicial imprimatur.
So even though the temporary court order became permanent in effect because the law changed, that sequence doesn't count.
According to the majority, no. The permanence didn't come from the court order itself. It came from an external event, the legislature's action. That linkage isn't strong enough under their rule.
That feels very technical.
Yeah.
Even if it makes for a clear rule, you get the result you wanted, the law changes, but because of the source of the final change, you don't get fees.
That's precisely the outcome.
Yeah.
And the majority defended this clear standard. They argued it serves judicial economy, it makes things simpler for courts, no more messy fights about why the government changed its mind.
Did they address the concern that governments might just repeal laws to avoid paying fees?
They did, but they dismissed those concerns as entirely speculative. They basically prioritized having a straightforward, easy-to-apply rule over worrying about potential strategic game playing by defendants.
Okay, but not everyone on the court agreed with this clear but maybe harsh rule. There was a dissent, right?
Yes, a strong dissent from Justices Jackson and Sotomayor.
What was their main point? Where did they think the majority went wrong?
Their focus was really on the purpose of the law, Section 1988, and the practical realities of civil rights litigation. They started with congressional intent, which was, they argued, to ensure effective access to the judicial process for people bringing civil rights claims. The whole point of the fee statute was to make it possible for ordinary people to hold the government accountable.
And they felt the majority's rule undermines that access.
Deeply. They argued that if lawyers know they won't get paid, even when their preliminary work forces a major change, they'll simply be less likely to take these vital cases in the first place. It creates a huge financial deterrent.
It makes sense. Lawyers have to pay their bills too.
Exactly. And the dissent really hammered home the reality of the relief these Virginia drivers got. That preliminary injunction wasn't just some abstract legal step.
It let them drive for 16 months.
16 months. They could work, live their lives without fearing that sanction. The dissent argued this was real, meaningful relief achieved because the court found they were likely to succeed on the merits. It mattered.
Did the dissent address the majority's point about strategic game playing being speculative?
Oh, they pushed back hard on that. They didn't think it was speculative at all.
What evidence did they point to?
They highlighted evidence from the case record, suggesting the Virginia DMV commissioner actively lobbied the state legislature to repeal that law.
Really? Why?
According to the dissent, internal communication suggested a key motivation was precisely to end the lawsuit and avoid having the department potentially incur costly legal fees.
Wow, so basically repeal the law to get out of paying the lawyers who forced your hand.
That's a dissent's interpretation. They argued this kind of strategic mooting leaves plaintiffs who successfully challenged an unconstitutional law holding the bag for their legal costs. They did the work, forced the change, but get stuck with the bill.
They used an analogy to make this point, right? Something about a protest.
Yes, it's a really helpful example to understand their concern. Imagine a group wants to hold a protest on a specific Saturday. The city says no.
Okay.
They rush to court early in the week. On Tuesday, the judge grants a preliminary injunction saying, yes, you can hold your protest on Saturday.
So they hold the protest. It happens.
Right. The protest happens successfully on Saturday. Come Sunday, the specific issue is over. The case about that Saturday protest is now moot.
But the plaintiffs got exactly what they wanted from the court order. That injunction was the final victory in practice.
That's the dissent's point. In that scenario, the preliminary injunction effectively was the final relief on the merits. But under the majority's strict rule,
no fees because the order was technically preliminary and the case became moot.
Exactly. The dissent argued the majority's rule lacks the nuance needed for these real-world civil rights situations where temporary relief is the whole ballgame. Timing is everything.
Okay, let's try to pull this all together. What's the big takeaway here, and why should someone listening care about this, this legal distinction?
Well, the court tension in Lackey v. Stinney is really about values. The Supreme Court majority valued a clear, predictable, easy-to-administer legal rule, a bright line.
Even if that rule makes it harder in some cases for people to actually pursue their civil rights.
That's the trade-off, according to the dissent. The court prioritized that clean standard over, perhaps, the practical ability of citizens to bring and fund meritorious lawsuits, especially when the main goal is stopping harmful government action quickly through things like preliminary injunctions.
So what's the immediate relevance for, say, someone involved in community organizing or just trying to follow policy debates?
There are a couple of key things. First, this decision likely makes it riskier and potentially more expensive to challenge government actions, especially if the government can just change the policy or repeal the law mid-litigation.
So it might discourage some lawsuits from even being filed.
Lawyers might be more hesitant, yes, especially if the primary goal is that quick injunctive relief. They know now that even if they get that relief and it forces the government's hand, they might not get paid under Section 1988B if the government acts before a final court order.
Okay, that's one impact. What else?
Second, just for understanding legal strategy, if you're watching or involved in a case, you now really understand this critical difference. Preliminary relief. That's temporary, it's about preserving things. Enduring relief. That's the final, conclusive, judge-stamped win.
And the rule is now crystal clear.
Crystal clear. To prevail for fee purposes, a court has to conclusively resolve your claim by granting enduring relief that changes the legal relationship, and crucially, both the change and its permanence must flow directly from a judicial order, not from the legislature, not from the defendant giving up voluntarily.
It really reinforces that if the government entity you're suing decides to concede or change the rules before that final judicial stamp,
The plaintiff, even if they achieve the desired outcome, might end up bearing the full financial cost of getting there. They force the change, expose the problem, but they might not recover their attorney's fees.
which brings us to a final thought to leave you with. The Supreme Court has set this strict rule for Section 1988B, but is that the end of the story?
Not necessarily. Congress can change laws the Supreme Court interprets. And they've actually done something similar before in a different context.
Oh, where?
With the Freedom of Information Act, FOIA, there were similar issues about whether people who sued to get records, and then the agency released them voluntarily, could get fees.
What did Congress do there?
They amended the FOIA fee provision. They specifically allowed courts to award fees if the plaintiff substantially prevailed, which could include situations where the lawsuit prompted the agency to voluntarily release the information. They essentially brought back a version of the catalyst theory just for FOIA cases.
Interesting. So Congress has shown it can step in when it thinks access to justice requires a different standard for fees.
Precisely.
So the provocative question we'll leave you mulling over is this. Given the very real access to justice concerns raised by the dissent in Lackey and the potential for governments to strategically avoid fees,
Will Congress feel spurred to revisit Section 1988B? Will they consider amending it to make sure that people who successfully challenge unconstitutional practices and force lasting change aren't financially penalized just because the government changed the law before the final gavel?
something to watch, definitely.
Absolutely. It's a fundamental question about how accessible our justice system really is for civil rights claims.
Well, that's all the time we have for this deep dive. Thanks for joining us.
Thank you.
We'll see you next time.